So in a 8-1 decision, the Supreme Court denied a stay that would have protected a state's Second Amendment sanctuary law. This law bars the state and its agents from enforcing federal laws, which in fact violate the Second Amendment. But despite that 8-1 order by the Supreme Court, the state is not giving up and they are still fighting back. So let's talk about what is going on. But real quick before we jump into this video, I want to thank the sponsor of this channel, which is Blackout Coffee. Blackout Coffee makes amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FBC and GOA. So if you want to support the two-way cause and you want to get great coffee, check out Blackout Coffee using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, in this video, we're going to be talking about an 8-1 order that was issued by the Supreme Court and how it's impacting a state's Second Amendment sanctuary law. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act, but the state is still fighting back despite that 8-1 order by the Supreme Court. In 2021, Missouri passed a law, the Second Amendment Preservation Act. The law set the state's interpretation of the Second Amendment and set restrictions on the enforcement of inconsistent federal laws. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws. Now, in response to the state of Missouri passing this law, the United States government decided, of course, to sue Missouri. In this case, the U.S. government sued Missouri under the theory that the law is unconstitutional because the statute is premised on an incorrect interpretation of the Second Amendment. Essentially, the U.S. government argues that Missouri's super pro-2A law and its interpretation of the Second Amendment, which is very pro-2A, is unconstitutional, and that the government's more limited interpretation of the Second Amendment is correct instead. The government argues that the summary language in the statute made the rest of the statutory language that was put in place invalid. The District Court on review agreed ultimately with the U.S. government and struck down this law in its entirety. The District Court issued an injunction preventing the state of Missouri and its agents from enforcing this law. Now, what is the law in question? Well, Missouri passed the Second Amendment Preservation Act through HB 85. The act declares that federal supremacy does not apply to federal laws that restrict or prohibit the manufacture, ownership, and use of firearms or firearms accessories or ammunition within the state of Missouri because such laws exceed the scope of federal government's authority. Any public officer, state, or local employee who tries to enforce a federal firearms law is open to civil suit and civil penalties of $50,000 per employee, which is then used to enforce that type of law. Essentially, this law allows any person, any resident in Missouri to sue a state agent or employee who tries to enforce a federal law that infringes on that individual's right to keep and bear arms or any other individual's right to keep and bear arms. This Missouri law is essentially similar to what Texas did with their SB 8 Texas abortion law and the recent Supreme Court decision in the Whole Women's Health case. That fact is also very important for why the Whole Women's Health decision was also referred to by Justice Alito in that recent 8-1 order by the Supreme Court. Now, if you're not aware, the Texas abortion law, or SB 8, prohibits an abortion if a fetal heartbeat is present. This law is different from other laws because it's not enforced by the state of Texas or any of its executives, but rather it allows any individual, any resident, to sue any other individual who performs or knowingly aids and abets in the activity. This means that the enforcement mechanism is not held with the state or any of its officers or agents. Instead, the enforcement mechanism is the private residents who will file these civil lawsuits. Now, here again is where things become relevant for Missouri's Second Amendment Preservation Act and the recent Supreme Court denial in this case. SB 8 shielded Texas and its officers and agents from lawsuits that they could potentially face because, again, they weren't the ones enforcing this law. Traditionally, the goal in these types of cases is to get an injunction against maybe like a state or whoever is enforcing the law, and that injunction prevents the law from actually being enforced. Because again, laws aren't necessarily struck down in their entirety. Instead, usually what happens is they are enjoined, and their enforcement is enjoined. And so the goal oftentimes with these types of laws is to get an umbrella injunction against the state, its attorney general, and all of its officers and agents. But again, the issue is, what if a state like Texas and its officers and agents are not actually the ones enforcing the law in question? You can't really get an injunction against them. Even if you do get an injunction against them, it's not going to resolve anything for you. So you can see how the structure of these types of laws are meant to avoid broad injunctions, and that's exactly what Missouri did with their law. They allow citizens to sue agents and anyone involved in the process of enforcing unconstitutional Second Amendment laws. So that's the backdrop of Missouri's Two-Way Preservation Act, which is in some ways kind of copied and applied some of these concepts to firearms. Now, this Missouri law was put in place before that, but it's a similar structure and scheme. The state removed themselves from enforcing the law, instead gave the citizens the power to sue state officials and their agents and anyone who's enforcing these anti-gun laws. Think of this as the state of Missouri saying, we believe in the Second Amendment so much that we're going to pass this super pro 2A law and we're not going to enforce it ourselves. Instead, the power is in the citizens to sue us and our officers and agents if we ever violate the law. Now, the district court on review struck down this entire Missouri law and enjoined the state of Missouri and its officers and agents from enforcing it. But again, as I outlined, here is the issue. None of those officers or agents or the state of Missouri were enforcing it anyways. The people are the ones who are enforcing it. Missouri, in response to this, then appealed the decision up to the 8th Circuit and also asked for a stay from the 8th Circuit while this decision was pending for an appeal. However, the 8th Circuit Court of Appeals denied that stay, and that then led the state of Missouri to file an emergency application for Supreme Court consideration and for the Supreme Court to grant a temporary stay. And recently, we got an order from the Supreme Court. It was an 8-1 decision, an order by the court denying that stay. The order of the court states that the application for stay presented to Justice Kavanaugh and by him referred to the court is denied. Justice Thomas would have granted the application for a stay. So again, it was an 8-1 order, and the only justice on the Supreme Court who would have granted Missouri's request for a stay was Justice Thomas. Now, in response to this also, there was a little note by Justice Gorsuch and Alito where they added some additional context, and that's where you got the reference to the whole women's health case. And this statement from Justice Alito and Gorsuch states that, with the understanding that the district court prohibited only implementation and enforcement of HB 85 by the state of Missouri and its officers, agents, and employees, and any others in active concert with such individuals, I agree with the denial of the application for a stay under the present circumstances. An injunction purporting to bind private parties, not before this district court, or the challenged provisions themselves, however, would be inconsistent with the equitable powers of federal courts. And there, in that sentence, they cite to whole women's health. Now, the goal of this was to get a stay from the Supreme Court, but only Justice Thomas was in favor of granting that stay. Now, typically, the Supreme Court does not like to get involved in these cases, especially at the early stage of these litigations. But more importantly, what was also interesting was Alito and Gorsuch saying in the order that essentially the district court's injunction only applies to the state and its agents, and it does not prevent private individuals who maybe want to sue the state or any of officers or agents who tried to enforce this law. And like I broke down, that's kind of the whole purpose of this law. So even though the Supreme Court issued that 8-1 order, I still would have preferred them to grant the stay, but in some ways they're also hinting at the fact that it still can be enforced. Now, despite this 8-1 order by the Supreme Court, the state of Missouri has not given up and they responded quick. They filed for expedited review of this case in the 8th Circuit because the Supreme Court stay denial has in some way changed the status quo of Missouri's laws. They're asking for oral arguments to take place at the earliest possible time, and the government's attorneys also did not oppose an expedited review of this case. And the 8th Circuit recently just issued an order expediting review of this issue. The order of the 8th Circuit states that appellant's motion for an expedited hearing is granted, and the clerk is directed to set the case for oral argument during the week of February 12th through the 16th of 2024. Counsel will be advised of the date, time, and location of the argument when the February calendar is published. So that's at least a small light of hope in this case, especially after the Supreme Court denied that stay. At least the 8th Circuit is taking into account what had recently happened in the Supreme Court and is trying to push this case forward potentially as fast as they can. Of course, it always could be faster, but at least they are setting this for expedited review, and it will be heard in early February. The hope is that on review of this case and on the review of the merits, the 8th Circuit ultimately will strike down the lower court's decision. Regardless, I think this is one of those cases that has some interesting facts and an interesting and nuanced approach that will eventually make its way back up to the Supreme Court, and the Supreme Court will have to review this and decide this case probably at one point on the merits. So this is a really interesting case, interesting situation. At least the 8th Circuit is taking this serious, it seems like, in an expedited review. But I'm not super hopeful for this. I think the only way that we would get something super significant out of this case is if it eventually makes its way back up to Supreme Court. But you have that 8-1 decision from the Supreme Court where they denied this stay. So you can take that for an indication maybe how the Supreme Court would treat this, but we'll have to wait and see. So if you guys have any questions, go ahead and comment down below and I will try to answer the best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.